Hey there again, I'm estate planning attorney Paul Rabelais, and in this video I'll describe the problems that people and their families face as they try to deal with banks and brokerage firms with their power of attorney documents, and how you can minimize and eliminate these common problems. So one of the biggest frustrations people have that relate to estate planning is when a bank or other financial institution refuses to accept a power of attorney document that was validly executed. So let's take a look at this and discuss what you can do so that you and your family don't run into a dead end when dealing with estate issues. No pun intended. So the first issue that people routinely face is that they present a power of attorney to a bank, a credit union, or a brokerage firm, and for some reason, the financial institution refuses to honor it. Let's say, for example, that 7 years ago, Dad signed a power of attorney appointing his daughter to have power of attorney for Dad. And now Dad, either because he had a stroke or now has dementia or some other incapacitating illness, Dad doesn't have the capacity to transact his own accounts. But the family thinks, no problem. Dad went to an estate lawyer 7 years ago and did many things, including signing a durable power of attorney. We'll just bring that to the bank so that daughter can take over Dad's accounts there and make sure Dad's bills still get paid. But the problem is when daughter brings the power of attorney to the bank says, we're not going to accept or honor this power of attorney. And maybe they give a reason and maybe they don't. If they give a reason, it might be the power of attorney is too old for the bank's liking, even though powers of attorney don't expire until the person who created it dies. Or they might say, we don't like the wording that's either in or is excluded from the power of attorney, with no legal basis for their rejection of the wording. Or maybe the brokerage firm might say, we only accept powers of attorney when they were executed on our financial institution's specific power of attorney form that our legal department created. And the problem is the family can't fix this problem because now Dad is in a condition where he doesn't have the capacity to knowingly sign something new to fix the problem. So now if daughter or a family member needs to access Dad's accounts to cover Dad's expenses, they'll have to go through a difficult court and attorney involved guardianship proceeding, which at best will take months or years and incur thousands or tens of thousands of dollars of court and attorney expenses. I suppose the main reason financial institutions often reject powers of attorney is that they are uncomfortable with their employees determining on their own whether a power of attorney is valid or whether the agent named on the power of attorney is acting within their authority granted by the power of attorney. And don't think this is an isolated problem. I've communicated with dozens of attorneys around the country, and they all have had clients that have been stuck because a power of attorney was rejected by a financial institution. So what should you do to avoid the potential problem of a financial institution rejecting your power of attorney? One option is to bring your power of attorney to your financial institution now and say, hey, I'm submitting my power of attorney to you to make sure my daughter can transact for me in the future if she needs to. And the bank will likely submit your power of attorney document to their legal team and hopefully give you an answer. And if they're willing to honor your power of attorney, they could go ahead and set up your daughter on the financial institution's records as having power of attorney for you. Or their legal department might say they aren't going to honor your power of attorney for some reason. Maybe they want you to sign something that says you haven't revoked your power of attorney since you originally signed it. Maybe they want you to sign the financial institution's own power of attorney form. Or for some other reason, you have to take some corrective action that the financial institution's policies require. But the idea is to take that necessary corrective action prior to your becoming incapacitated when you can't take any corrective action. Now, one remedy, I'll call it an informal hack that many people implement that solves the problem of your financial institution not honoring your power of attorney, is to make that person who has named your agent on your power of attorney, make them an authorized signer on your bank account now. Not a co-owner or joint owner, but an authorized signer. Or grant them full authority to transact your brokerage account. Some people will say, don't put your child as a signer on your account because they could go to the bank and withdraw all your money. Or people will say, don't put your child as an authorized signer because if your child gets sued and someone gets a judgment against your child's creditor will attempt to seize your account because your child is listed as an authorized signer. Well, most consumers ignore that advice either because they trust their child that they are putting on their bank account, or their child is not in the middle of a lawsuit where a child's future creditor could attempt to seize your interest in your bank account. Bottom line is, I bet we all know people who have added a child or some other person as a signer on their bank account so that the child can access the account when the parent can't. It's just something a lot of people do with or without legal advice. Now, some states have enacted legislation that can provide you and your family with some protection in the event they refuse to honor your power of attorney. Florida, for example, provides, among other things, that third parties must accept or reject a power of attorney within a reasonable time. For financial institutions, 4 business days is presumed to be a reasonable time. Third parties who violate this set of Florida laws regarding powers of attorney may be subject to a court order mandating acceptance and liability for damages incurred in compelling them to accept a valid power of attorney. And some state legislatures have created and enacted statutes so that states now have their own what's called statutory power of attorney. The idea behind using a statutory power of attorney is that the statutory power of attorney copies the language in the state statute, and third parties are familiar with these terms and the language in the statutory power of attorney, and so third parties may be more confident accepting the power of attorney. But still, we see circumstances where third parties are rejecting statutory powers of attorney. Now, California has enacted legislation that says if a third party refuses to honor a properly executed statutory power of attorney, the third party may be compelled through a court proceeding to honor the power of attorney. But having to take a financial institution to court to force them to honor a power of attorney takes a great deal of time and effort, even if a court can force that third party to pay your attorney fees. Another solution to financial institutions refusing to honor your power of attorney is to transfer your financial accounts to your revocable living trust. Then, in the event of your death or future incapacity, your successor trustee can present your living trust instrument to your financial institution and obtain access to your trust accounts. And while I'm sure there are a handful of stories out there about financial institutions failing to honor a validly prepared trust, the problem is not as rampant as financial institutions failing to honor a power of attorney. But the problem with this analysis is that you likely own accounts that can't be put in a trust. If you have a Roth or a traditional individual retirement account, an IRA, a 401k account, or other similar retirement account, those accounts must remain in your name during your lifetime. You're not permitted to transfer ownership of those accounts to a trust during your lifetime. So you must rely on your power of attorney to enable trusted loved ones to be able to transact for you if at some point during the rest of your lifetime you can't transact your account for yourself. So the moral of this story is that sometimes signing those estate documents that the attorney prepared for you is not the end all of making sure all your estate legal affairs are in order. Following up with your financial institutions post-estate planning signing to ensure that trusted loved ones can do what they need to do in the future on your behalf can be that ounce of prevention that can avoid a future pound of cure. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me, where we'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through our national estate planning law firm, America's Estate Planning Lawyers. Now go ahead and have a great day.